for what are debunked, frivolous, sovereign arguments.
And they want to say that they're not happy about it. What is the problem?
And the stranger was the one that actually shot you, not Mr. Barrisone. That's the same situation.
And that you had contact with her on the 20th. There was some physical.
Contact with her on the 20th.
Mr. Brooks, this is my time. You need to not interrupt.
That's the reason why the charge was dropped.
Mr. Brooks,
the state
you need to stop.
said specifically, wrote you, Your Honor, and said that they know it was no incident that day.
Mr.
And
Brooks,
now you want to sit up here.
do not interrupt me or you will be removed to the other
and now
courtroom.
you want to sit up here
Stop.
and try to
now.
add something in that you know for a fact never even happened. You want to sit up here
Mr.
and talk
Brooks,
about
every
who has
time-
grace and all this. You talking about someone with 5 kids that don't have custody.
You need to stop
None of
right
them.
now or you will be removed.
Remove me then.
All right? He will be removed. He cannot simply stay
I don't
quiet when
consent
this
to being
court talks.
sentenced anyway. I don't consent to this. Just like I told you, I don't know the.
He'll be in recess until he's
I don't
removed
even
to the other
understand
courtroom.
the true nature and cause.
Implicit adoption of what he was saying, this improper arguments, and the court should chastise.
Okay, but what you are doing right now is highlighting something and making more of a spectacle. So if your office in general does not want to facilitate or incite violence, then we need to just sit down and move on. That's it. There were 18 witnesses, 16 or 18 witnesses that testified today. There was nothing that was said until Ms. McNeil made her point made, and, you know, we're moving on.
But is the court going to do anything about maybe stopping it from happening again?
When these people are upset about specific things that have gone on from that table, like shooting the middle finger up at this court and laughing and joking, Ms. McNeil, be quiet. When these people have sat in this courtroom and watched this behavior from that table, and they want to say that they're not happy about it, what is the problem?
Judge, I have no problem because I have thick skin. But once you bring in my children, I think that's highly improper. And it's because of
I didn't even know you have children. I don't know what you're talking about. Your children? What about your children?
First of all, Your Honor, this was the subject of a motion. I'm well aware of that. And the court left the door open.
For me, not for you.
My understanding of
You should have come and asked for reconsideration. You did on the one motion, and in fact, I granted your motion for reconsideration.
That was not our motion.
Excuse me. I did. I granted.
We did not move
that
to
was
reconsider.
their motion.
We have not filed
forgive
any
me.
motions to reconsider
Forgive
in
me.
this case.
That was their motion for reconsideration, which I denied. But I said I denied it, or I indicated a bias towards denial is what I did. Held it open with a bias towards denial. Why would you think that that made it okay for you, without any advance notice, to bring this matter before the jury? I was astonished when you began your examination by commenting on the defendant's post-arrest silence. That's basic law. It's been basic law in this country for 40 years, 50 years. I have no idea why you would do something like that. And it gives, well, I'll leave it at that. So I don't know what you're up to.
May I respond?
Yes.
We filed an other acts motion on this exact issue because, in my mind, and I argued this, it is identical to what was going on the night of August 25th, in the sense that the defendant was using this exact same weapon. He was using it in a manner to try and protect property.
No, he wasn't.
Your Honor, with all due respect,
I'm not going to rehash the motion. That's absolutely untrue. No. Your argument's of record. My comments are of record, and why I ruled as I did is of record. There's nothing that I heard in this trial to suggest that anything's changed, even if you're correct in your assumption that you know more than I did at the time. You should have come to the court and say, I want to go into this. Why you would think that you could go into it without any advance notice to the court, I don't understand that. And as the defense is pointing out, you're an experienced trial lawyer, and this should not have been gone into.
Your Honor, there have been things in this case, testimony in this case, that I believe opens the door to this. For example, The defense has introduced evidence that the defendant pointed a gun at a man wearing yellow pants because that person was on a car on the car source lot. Now, there's no justification that I can think of why the defendant would point that gun at someone. The defendant has just testified this morning that he agreed with that person in the yellow pants, that he pointed the gun at him. He said, I was joking when I said that to the guy in the yellow pants, but he said, he's acknowledged that he told the person in the yellow pants, yeah, you're right. I did point a gun at you when you were sitting on a car.
He said, I did. That's what he
Exactly.
testified.
So he's agreeing. May I finish, please? I'd like to have a chance to make a record if I could, without being interrupted, if that's okay. It wasn't excluded, Your Honor.
You know why it was excluded in the first place? Because it was propensity evidence. That is exactly what 90404 is designed to prevent. You're talking about his attitudes. His attitude is he wants to shoot people. Now, I've admitted that kind of evidence in other trials when it's been appropriate. I didn't admit it in this case because, to me, what I've heard in this trial, and by the way, Mr. Richards absolutely correctly points out that just hours ago, I said I had heard nothing in this trial to change any of my rulings. So why?
Testimony, Your Honor.
Pardon me?
That was before the
Don't
defense testimony.
get brazen with me. You knew very well. You know very well that an attorney can't go into these types of areas when the judge has already ruled without asking outside the presence of the jury to do so. So don't give me that. That's number one. Number two, this is propensity evidence. I said at the time that I made my ruling, and I'll repeat again now for you, I see no similarity between talking about wishing you had your AR gun, which you don't have, so that you could fire rounds at these thought to be shoplifters, and the incidents in these cases, which are not, there's nothing in your case that suggests the defendant was lying in wait to shoot at somebody or reflecting upon the shooting for a vast amount of time. Every one of the incidents involves matters that involve seconds in time. So I commented at the time, I don't see the similarity, and I don't see the similarity now. If it's not similar, that's the whole rule. Those are all the exceptions to 90404. Check the authorities. Wigmore and evidence. Judge Weinstein. Colonel McCormick. It's the prior act has to bear the signature of the accused, or it has to be so similar as to suggest it's a common plan or something like that. You have an incident where he's making comments about some alleged shoplifters versus crimes that involve instantaneous actions, whether premeditated murder or whether self-defense, that's for the jury to decide. But I don't see the similarity. I said it couldn't come in, and it isn't coming in, no matter what you think. Number two, I have to be concerned that with what Mr. Richards has said about the progress of the trial, and when you were I said you were over the line, close to or over the line on commenting on the defendant's pretrial silence, which is a well-known rule. I'm astonished that would have been an issue. So I don't want to have another issue as long as this case continues. Is that clear?
It is.
Thank you. Ask the jury to come back in, please.
That's not a subpoena. The subpoena is when you actually get the subpoena paperwork by mail, or I don't.
Mr. Brooks, you need to ask a question.
Can I get to it, Your Honor?
No, because you're trying to define something, which would be testifying, which you cannot do at this time. So the jury will disregard his last comment, but go ahead and ask a question of this witness.
You get something else. Wow.
Mr. Brooks, that was inappropriate. Do you have any other questions
Yes,
for this
I do.
witness?
Yes,
Please
I
ask
do.
them. Would like to get through one more witness, but I want to take a short comfort break for everyone, so I'll rise for the jury. Thank you. Mr. Brooks, not now.
Not allowed to.
Not now. The jury is in this courtroom, and you will show respect for them and for this court.
Respect for them would be
Mr. Brooks.
telling them the truth.
Stop. I'm putting you on notice that you are on the verge of this court creating a curative instruction about your frivolous arguments. I will not have you claim legitimacy for what are debunked, frivolous, sovereign arguments.
Then
That is why
prove it.
your questions
Prove it.
are being
Prove that it's
objected
frivolous.
to,
Prove
and
that
why
it's frivolous. Prove it.
all the cases that we've already referenced, sir. We are in recess. We'll be back
And
in
prove
5
it.
minutes. Thank you, everyone.
I don't agree to an estoppel. Can you prove it?
Away from the jury. How anybody in their right mind could listen to these proceedings this morning and report that, much less Elizabeth Williams in the New York Times, why they have her covering this case when
Well,
she
I
wrote
don't
it.
want to
No,
go
no,
down.
Judge, I'm
No,
gonna-
Attorney Pattis, I don't.
May I please be heard?
No.
May I be heard?
No,
Because I'll do it on the
no.
courtust steps under
You-
3.6b
then
if I
suggest you-
have to.
Attorney Pattis, I have made it so clear that when I'm speaking, you have to stop speaking. You've got to you just can't push it like that. You are welcome to leave this courthouse. In fact, you're welcome, I suppose you could stay in the courtroom and say whatever you want, but when I'm on the bench
Got it.
and I tell you to stop speaking, you need to stop. I'm going to say this again. I don't know how I'm not making myself clear, and maybe it's my fault. I do not want to sanction an attorney. I do not want to fine an attorney. I have gone almost 2 decades as a judge and never had to do that. And I don't want to do it now. But if we have a continued problem where you're talking over me, I don't know what else to do. I've asked you nicely. I'm literally almost begging you. I have no recourse but to do that. So I'm not asking for your response, but you are certainly welcome to say whatever you would like to say when we're not on the record in the courtroom. That's your right to do so, and I know that you will abide the rules of professional conduct along those lines. I want to just get back and say this. I am responsible for what happens on the record in this courthouse, in this courtroom, and I am not responsible for any other issues. So I don't want to respond to that or go down and address any such statements. My concern was that there were safety issues, or that there were statements made to the families, the plaintiffs, or to Attorney Maddie, given that we had the issue earlier. But I am so happy that that is not the case. So I think we can move on from this issue. And I think hopefully you will use your powers of persuasion, and we won't have any further issues where Mr. Jones is suggesting that the jury not follow their oath, frankly. So can we please move to the earlier filing about the curative clarifying charge?
May I be heard just because under Phillips v. Ward?
I don't think so, Attorney Pattis. I'm not giving you the opportunity. It's not a give and take here. I've said what I've said, and I think that is all I'm going to do on the topic. So are you prepared?
I'm begging you for an opportunity.
No, not at this, Attorney Pattis, no, I'm sorry. Do you want to be heard on your, the curative charge now?
I have one more issue to raise with regard to the press conference, Your Honor.
Well, I'm not giving Attorney Pattis any further opportunity to address it. I think there's nothing at this point that I need to do. If you disagree, I encourage either or both of you to file something in the file.
No one was jumping up when they were referring to the defense children. No one jumped up to try to tap down that rhetoric. That is the rhetoric that I'm talking about. That is what I'm trying to be very clear on. Jeff Marcus, the state, they can hide behind their arguments, but we all are witnessing what is occurring in this courtroom.
Which is myself. I'm a judge,
And
and I understand that I'm in
Thank you,
charge
Judge.
of the decorum, and I feel that 99% or a great percentage of what has been said has been appropriate. Everybody has maintained decorum, but for a few comments, it's best to just move on as opposed to highlight them.
This is true, Judge, but I am witnessing a building of momentum, and I'm encouraging the court to direct the state to tap down on that momentum so it does not reoccur and it does not become a theme. Thank you, Judge.
Your Honor, for the record, the only thing the state has said to any of these witnesses when they get up is, would they like to say something on behalf of the victim they're representing? There's been no encouraging or inciting, as Mr. Weeks has put on this record. That is a blatant falsehood and a recreation of the record. As far as no objections being made, it's the defense that could have objected. It's not the state's duty to object to their own witnesses when they're testifying.
Okay. Listen, I've already heard. If you have anything else to say, you can put it in writing at a later time. I've heard from both sides more than once. That's going to be it. I've made my decision. Like I said, 99% of what's been testified to has been appropriate. I do not want to highlight the few things that were said that were perhaps not appropriate, and let's move on.
Judge, I'm asking for 20 seconds to ask.
You can have as many seconds as you want in writing, and you can put all of your objections in writing. They've been made multiple times from your chief assistant, from Ms. McNeil, and I don't want to hear anything else. I've already heard it. Is there something that has not already been argued?
Yes, ma'am.
Okay, exactly what is it?
Judge, before Mr. Schachter took the podium and testified before this court, I wanted to reflect that both Mr. Marcus and Mr. Satz looked at the statement prior to the reading. And so their implicit adoption of what he was saying, of this improper arguments, and the court should chastise.
Okay, but what you are doing right now is highlighting something and making more of a spectacle. So if your office in general does not want to facilitate or incite violence, then we need to just sit down and move on. That's it. There were 18 witnesses, 16 or 18 witnesses that testified today. There was nothing that was said until Ms. McNeil made her point made, and, you know, we're moving on.
But is the court going to do anything about maybe stopping it from happening again?
When these people are upset about specific things that have gone on from that table, like shooting the middle finger up at this court and laughing and joking, Ms. McNeil, be quiet. When these people have sat in this courtroom and watched this behavior from that table, and they want to say that they're not happy about it, what is the problem?
Judge, I have no problem because I have thick skin. But once you bring in my children, I think that's highly improper. And it's
I didn't even know you have children. I don't know what you're talking about. Your children? What about your children?
For them to comment on my children is highly improper, and for this court to allow that kind of testimony is also improper.
I don't remember any comments about any children. And if there was, it obviously didn't, it came and went without me noticing it.
Judge, I can assure you that if they were talking about your children, you would definitely notice it.
You need to sit down right now. You're out of line. In fact, you're excused. You need to go sit in the back with your chief public defender.
He's the public defender, Judge.
Mr. Weeks, please ask the lawyer from your office to go sit down and not say anything else. To try to threaten my children and bring up my children is inappropriate. Go to the back of the room now. That just violated about every rule of professional responsibility that I have never. If you're going to get up here and you're going to...
Judge, I asked you to go sidebar on this matter.
You, sidebar or not, you don't have one of your assistant public defenders say something about my children?
Judge, that same venom that the court is expressing is the same venom that defense counsel had to sit through this entire morning when their children
She brought up her children multiple
referenced.
times during the trial. Nobody knows if I'm barren or not. They don't know about my children.
Judge.
Sit down. Sit down.
Judge.
Sit down, Mr. Weeks.
Please do not summarily dismiss me.
I'm summarily dismissing
I'm asking
you.
the
Go
court.
sit down.
I'm asking the court. I asked the court to go sidebar.
Go sit down. You don't threaten The
Judge,
court's children.
everyone in
Your
this
assistant just
courtroom-
did that. Go sit down.
No one in this courtroom had to endure what we had to
Go
endure.
sit down. Miss McNeil has made her children a spectacle more than once during this trial. That was her choice. You have absolutely no right to have one of your assistants come up here and suggest something about my children. Now, please go sit down.
Judge.
You're
Judge,
inappropriate and out of line. Go sit down.
Judge, may I have a brief recess?
No. Go sit down.
May I have a brief recess so I can speak to my attorneys?
We're moving on with the sentencing, Mr. Weeks.
So can I have a brief recess?
No.
Thank you.
It's 1:36. Thank you.
What's the nature of your objection, Mr. Shellhorn?
Judge, I think there was a question there suggesting that the attack, the dog bite, and I think there was something else was going on before any shots were fired. I'm
Yeah,
not sure
I don't even know what
Exactly.
the, I don't even know what the factual basis is for that.
Judge, I can ask a witness.
No, you
whether-
can't. No, you can't. Not without a factual basis. You just can't ask for speculation. That's what you're asking
I'm
for.
asking you a question whether or not,
There's no evidence that it happened before. None.
Judge.
Not a scintilla
I believe.
of evidence on the record so far
So
that
if
that
a wit-
supports that question.
If a witness says that something happened, I can't ask them if.
You've asked them 500 questions about what happened, about her recollection of it, which is fine. Now you're asking, well, are you sure it didn't happen before? You have no basis to ask that.
Her recollection is horrible.
No, it's not.
She's changed her story over and over.
It doesn't matter. It doesn't,
It's-
Mr. Belinkus, it does not allow you to suggest to this jury to engage in speculation, which is what you're doing. Your client doesn't remember the incident,
Judge,
according to the expert reports. So that's not a factual basis for you.
Judge,
And there's nothing in this record to suggest that any of this happened, the beating, the phone, the dog bite, before. In fact, we have a 911 call where it's patently obvious that the dog is in the area because it is incessantly barking and heard over the 911 call, which is after the shooting. So you need a factual basis. That is black letter law 101.
my factual basis, Judge, is that these people, both Cataract and Goodwin, have a motive to lie with regards to what happened. They filed a lawsuit, there's hostility, and
But again, even assuming all that's true,
so why?
there's no evidence in the record. That's like saying, well, isn't it true that a stranger drove down the road when Michael Barrasone was there and got out of his car, and the stranger was the one that actually shot you, not Mr. Barrasone? That's the same situation. There's no evidence in the record that that happened. You're just trying, you're trying to create in the jury's mind some alternate issue without any facts in the record to support it. Now, if Mr. Barrasone were going to testify about something, that's different. But the experts have said he doesn't remember anything about the incident.
Understood, Judge, but again, whatever ruling you make, obviously, I abide by, but in this particular case, this witness's testimony, as well as her boyfriend, which are basically the only two pieces of evidence.
No, and the 911 call,
Okay.
which lays out exactly what happened immediately after the shooting.
Immediately after the shooting, and I believe I can question the timing of the shooting based on their inconsistent statement, their motivation to lie.
No, you're not going to, not to create some alternate universe scenario without something in the record.
Well, I can't get anything in the record, Judge, unless I could ask these questions.
No, there's plenty in the record so far. There's plenty in the record so far, but nothing in the record to show that the beating, the dog bite, and everything happened before the shooting.
Well, Mr. Goodwin is going to testify, Judge, that Mrs.
Well,
Cataract disappeared for a significant period
All right,
of time.
well, then ask him that. Ask him that question.
It's implausible for someone to
It
be
doesn't-
shot.
Mr. Belinkus, I can't predict what's going to go on the record in the future when other witnesses testify. If the scenario changes, then you can ask it then. At this point in time, there's nothing in the record to suggest a scenario that you want to ask in a question for the jurors. There's not.
Judge, okay.
That's my ruling. End of it. All right. I'll go off the record now because you have to...
Speculative.
Overrule